Just a reminder to everybody that this conference is being recorded. So welcome to today's session on copyright law. Copyright law can be a complex and expensive area to navigate, especially in today's right-click, save and share digital world. The rise of smartphones and mobile tablets, along with growing social networks, give consumers and businesses the freedom to capture, share and source images at the touch of a button. Therefore, it is so important to understand some of the key copyright considerations and how these might apply when consumers and businesses want to use content. The purpose of this seminar is to create awareness about copyright to help consumers and businesses avoid potential issues and pitfalls before they may arise, so that we can all stay on the right side of copyright laws. The ReadyTalk webinar tools allow participants to type questions in the text box. Given the large number of registered participants, I will address the questions at the end of the webinar, but please feel free to add questions or comment to the questions panel at any time. If time permits, I will do my best to get through all the questions. However, if I do not get to your question, you can reach out to Getty Images by the email alias that appears in the collateral that will be available following this session. Rather than spending our time dissecting the various legislative frameworks that exist around copyright, we will focus on the practical application of copyright by discussing some examples and hopefully providing you with some hopeful tips that you can take away from today's session. In saying that, we will very briefly go over some copyright essentials, just to make sure that we are all on the same page in terms of what copyright provisions might apply when businesses and consumers want to use content. This session will also provide tips for using works that are subject to copyright, and we will discuss some additional content considerations, as other intellectual property rights may exist within works. Finally, I will consolidate the key takeaways from this webinar in a checklist. What actually is copyright? Copyright is a set of exclusive property rights given to owners in relation to their creations. In most countries in the Asia-Pacific region, there is no system of registration, so copyright is automatically applied to the creation. For example, as soon as a photographer points, shoots and captures a photograph, that image is automatically subject to copyright. These exclusive rights of the copyright owner allows the creator to reproduce, publish, distribute, display, perform, communicate and adapt their original work. If anyone else wants to do any of these actions that are exclusively reserved for the copyright owner, permission is needed from that owner. To obtain permission, copyright can be licensed or even assigned to another party, as the copyright owner is the only person or the only party with the right to control the exploitation of their work. The term or duration of copyright varies depending on the region in which the work was created, according to local copyright laws, and can also often depend on the type of creative work. Very generally and broadly speaking, copyright can last anywhere between 25 to 70 years after passing of the creator. On this slide, I have included a reference to the various copyright laws in Southeast Asia. We will not go into specific details about each of these acts. Rather, we will focus on the key themes that are prevalent throughout the region. I always put this on a separate slide in red and in bold, as this is most likely one of the most important things that I will say in this session. If anyone wants to use a work that is subject to copyright and do any of those actions that are exclusively reserved for that copyright owner, you must have permission from the owner. Typically, this is in the form of a license. There are very few exceptions to this rule, and even then, those exceptions are very narrow and limited in application. For example, work can be reproduced in the course of legal advice. But it's important to keep in mind that these exceptions certainly would not apply to advertorial or promotional campaigns or marketing collateral or even personal use in a blog. There are a number of works that are protected by copyright. These include literary works, musical works, artworks, motion pictures and films, computer programs, television and radio broadcasts, and performances. Of course, this list is not exhaustive. These are purely examples of the types of works that are subject to copyright. If anyone exercises the exclusive rights of the creator that we touched on before, such as making copies or distributing or adapting, without proper permissions in place, this will be a copyright infringement. If you don't ask permission or have a valid license in place to use an image or even just part of an image, then this would be considered a copyright infringement. In the digital world in which we live, it's very easy to right-click and save an image. So it's very important to keep in mind that if we want to reproduce a saved image, we need prior permission from the copyright owner. A copyright infringement can also occur if the content is used beyond the scope of a license. For example, if you have secured a license to use an image for 1 year on your company website, but 2 years later that image still appears on their website, or you decide to use that image on different platforms rather than just your website, this use will also be unauthorized. A helpful tip is to keep in mind that some licenses expire, so keep track of any expiration dates and be ready to either remove or relicense that content. Another example of copyright infringement is adapting a work without the relevant permissions. The rights you are granted will most often be detailed in your license terms and conditions, so be sure to read those T&Cs that are attached to your license so that you understand the grant of right that has been given to you. For example, editorial images such as news and entertainment content should not be manipulated, as this will ensure that the editorial integrity or the story that's being told behind that picture is upheld. Why do we need to worry about copyright? For creators, receiving royalty payments for use of their works is the way they make their money. It's their livelihood. So most creators are very prudent about protecting their rights and ensuring that they are properly remunerated. So it is possible, and quite likely, that the creators will keep abreast of any uses of their content and question if there are valid licenses or permissions in place for their uses. If it turns out that you have infringed someone's copyright, they or their representatives are able to bring legal action. With growing technological advancements and improvements, there is a vast array of technology that identifies infringers. PicScout is an example of one of these platforms, and we will go through this in a little more detail soon. So just keep in mind that it's not just that the creators that are looking out for infringements of their rights. There's also technology that identifies these infringers. Bad PR is also another reason why we should be worrying about copyright infringements. If you do infringe a creator's copyright, bad PR may follow. Social media is a growing forum where creators whose rights have been infringed may vent their frustrations about a particular company or individual who has committed copyright infringement. Often, the bigger the company, the bigger the story, which may also be picked up by newspapers and other media. There are a number of misconceptions surrounding copyright, and we will go through some of these myths so that we can be adequately informed when making decisions about using works that are subject to copyright. It may be surprising, but all points on this slide are myths. Copyright laws generally apply to materials on the internet in the same way that it applies to other platforms. Many websites have specific copyright statements that relate to the content on that site that tell you what you can and cannot do with the content that appears on that site. If content is on the internet, it doesn't necessarily mean that it's in the public domain. Therefore, permission must still be sought. Likewise, just because there is no copyright statement or watermark doesn't necessarily mean that you have the right to copy that material. I often hear individuals say, if I don't profit from the use, then I don't need permission. This is incorrect. If anyone wants to enjoy any of those exclusive rights of the creator that we talked about previously, permission must be obtained, regardless of whether or not a profit is generated from the use. When it comes to social media, it is really important to make sure that you abide by the terms and conditions of the relevant social media platforms. Generally speaking, most social media networks allow users to enjoy the inherent tools of that platform. For example, resharing a post or retweeting. However, this does not mean that you can copy and paste or extract the content from that platform and use it for your own purposes, outside those embedded tools and functions of that social media platform. If I alter an image, I don't need permission to use it. Once again, this is incorrect. If you are planning to use an adaptation of a work by changing the image to black and white or creating an artistic illustration, you still need permission from the copyright creator. Another misconception is that royalty-free images means that you can use an image for free. Royalty-free is actually a licensing model, and it generally means that you can pay a once-off fee and have very broad, worldwide, perpetual rights to use an image without paying a royalty fee for every single use, as is the case with many other licensing models. The last example on this slide is important to show where responsibilities lie. If you are the URL or domain name owner, you are the one that is ultimately responsible to ensure that the images appearing on your website have been correctly licensed. It is a good idea to ensure that your web designer, who may have licensed the images on your behalf, lists you and or your company as the end user of the images to avoid any confusion about who holds the rights to display the images on their website, to ensure that you are the appropriate rights holder of a license. If you are a web designer, although the liability does not rest with you in this case, or this example, it is ideal to ensure that clients have the appropriate license in place from a relationship management point of view. If you are not sure who is the creator of an image, there are many free online tools and apps such as PicScout or reverse image search that will help you find whether an image is available and where and how you can license that image and secure the relevant permissions. One of the most common problems we come across is that of small businesses failing to seek assurances from creative agencies or third-party designers that a valid license has been secured. So make sure that when permissions have been sought, you keep copies of these licenses and calendarize or track any expiration dates. We often hear that business owners were simply not aware that they were required to renew their license or replace the image once the license had expired. It's also very important to know and understand the terms and conditions of your license, as there are many different types of licensing models, such as royalty-free, with that traditional broad rights offering, to rights managed, with very specific grant of rights. Many licenses often have very specific restrictions, such as no use in a logo, no pornographic or defamatory uses. So make sure that you read the terms and conditions and ask questions if you're unsure of the meaning of how a certain term affects you. One of the best tips I can give when wanting to use content is, if you don't know where an image originated or who owns the copyright, it's best to seek an alternative image if you want to use it, so that you can contact the copyright owner to obtain the relevant permissions and avoid committing a copyright infringement. Lastly, it's important to think about other intellectual property rights that may exist within an image, or whether or not you need permission from any property owners or people that may appear in the image before you use it. We'll go into this in a little bit more detail in later slides. This slide shows an example of how you can find a copyright owner. The launch tool on the PicScout website is a quick, easy, and free way to identify creators and where to license content. One of the benefits is that you do not need to download any specific software or save the program on desktop. Given it's a web-based program, you can access the URL at any time. All you need to do is click on the launch tool, upload the image that you want to use or that you want to know more about, and the tool will populate the results for you. When you are securing a license for your use, it is very important to make sure that the licensing model and associated terms and conditions fully encapsulates your planned use. For example, if you plan to use an image on your brand's social media networks, you must ensure that your license allows that specific use or those rights. There are other licensing models, such as Embed or Creative Commons licenses, that allow permission for use of content. Likewise, it's very important to read the terms and conditions of those licenses, as many of these free licensing models allow for personal or editorial use only, such as on a blog, and require an attribution or a credit to the copyright owner. In addition, many of these free licensing models do not provide any warranties or indemnities. So depending on your needs, you may need to look to alternative image sources that do provide the relevant warranties and indemnities. Many free libraries or platforms and some licensing models do not even allow for commercial use at all. Therefore, if you plan to use content to promote a product or a service or a brand or a native advertising, or in any way where there is a suggestion of endorsement or sponsorship, you need to ensure that your license provides for these specific rights. Otherwise, you might be committing a copyright infringement. So make sure that your proposed use is covered by the license terms. Often, content that is subject to copyright contains other elements that are also subject to copyright and other intellectual property laws. If you're using content for commercial purposes, you may need to think about obtaining additional releases. Let's take the image on the slide as an example. If this image were to be used for a commercial purpose, so to promote a brand or product or service, or in content marketing or native advertising, you would need to think about getting permission, well, firstly from the photographer via a license so that you can secure the relevant copyright permissions, given the copyright considerations that we have previously addressed. You might also need to obtain permission from any people that appear in the image that are recognizable. You also might need to obtain permission from the artist of any of those artworks that appear within the image. And lastly, you may also need to obtain permission from the art gallery, particularly if an admission fee is paid to enter the gallery. So there's lots of additional considerations that we should all be aware of. If using content for a commercial purpose, keep in mind that you may need releases or permissions from recognizable people, building owners, trademark owners, animal owners if the animal is used for profits, and artwork creators. It's not just celebrities that are recognizable. Each image on this slide contains a person or people that are recognizable. There are many things that may make someone recognizable, and you should think about whether or not your use is commercial and whether or not you need to seek a release or permission from the people appearing in your image. Features that might make somebody identifiable include distinctive hairstyles, scars, birthmarks, any unique features, surroundings, costumes and uniforms can also make somebody identifiable even if you cannot see their face, crowds and groups of people, and also tattoos can make somebody identifiable even if you can't see the face of the person that has that tattoo. Additionally, a tattoo is also an artwork. So the tattoo itself might be subject to copyright of the tattoo artist. You probably wouldn't need to be as cautious with common tattoos, like a simple or straightforward anchor on an arm, but most definitely should be sensitive to tribal tattoos and other unique detailed tattoos. If you plan to use buildings, private homes, businesses that display trademarks, and landmarks for commercial uses, you would also need to think about obtaining permission. One way to reduce your risk is to use an image of a skyline or a cityscape where there is no particular focus on one building. It is important to keep in mind that cropping an image or using an image that focuses on a particular building or landmark increase the risk of a successful claim. If an image contains an animal that is used for profits, for example, animals in a circus or a zoo, you would also need to think about obtaining releases from the animal owner if your planned use has a commercial purpose. You should also watch out for artworks like paintings, sculptures, drawings, and maps. If the image contains any of these types of works and your use is a commercial purpose, you may need to think about obtaining releases from any artists or sculptors or composers. If the artwork is a recreation of a celebrity image, such as the Bruce Lee statue in Hong Kong on the left of this slide, you may also need to think about obtaining permission from the Bruce Lee estate for using his likeness. Here is a recent example with the clothing brand 11 Paris that used celebrity images without permission from the celebrities. Beyonce, Rihanna, Pharrell have all pursued 11 Paris for using their likeness to sell without their permission. I believe there are also additional celebrities that have pursued in this case. Here is another recent example where images of this grandmother were used on greeting cards. The family of the grandmother pursued for this commercial use. Here, the customer had licensed these images from Getty Images directly, and these were actually licensed with the relevant model releases. The customer was able to turn to Getty Images for assistance, and we handled this directly. This actually turned out to be a case of mistaken identity, as we did have signed model releases on file. So we were able to handle this for this customer. This is an example of a copyright infringement case. The Hope poster on the right of the slide was created and distributed during Obama's first run for presidential election in 2008. The poster was based on a photograph taken on the left, but permission was not sought, and the photographer was upset that their work was not credited. This claim was settled out of court. One of the most useful and practical tips I can give when licensing an image from a photo library is to make sure that you check the release information on the asset detail page. This will tell you if the image does or does not come with a model release or property release. If the image does not have any releases and your use is commercial, so remember to promote a brand or product or company, you should think about whether or not you need to obtain any additional releases. This checklist will help you safeguard against potential legal action. You need to ask yourself, do I have permission from the copyright owner to use this content? Have I kept a copy of the license that governs my use so that I know the terms and conditions that apply? Have I thought about any additional releases for my use if my use is commercial? So that's those model and property releases that we were talking about. And lastly, how do I get these necessary releases? Perhaps I have a relationship with the talent or the property owner. Or can a photo agency assist me in obtaining any special clearances or permissions? For additional resources, you can reach out to your local intellectual property office. Content providers often also have free newsletters or FAQ documents and other publications about copyright. There are also many free online tools such as PicScout, Reverse Image Search, and TinEye that can help you find the source of an image. So that concludes the information piece of today's seminar. So I'll move to answer any questions that you might have. I'm just going to scroll up in the participant feedback section. Okay, I'll read a question from Apizit. I have a question about if I took a photo and give it to my friend to use for his website. I then sell that photo to Microstock website. Is the photo that my friend used would be infringement of the photo? So there are a couple of things to keep in mind here. So firstly, you are the copyright owner of the photograph if you took that photograph yourself. And if you have given that photo to your friend to use, you've given them the relevant permissions. So that will be fine if your friend is using the image that you have taken because you've given them the relevant permissions. One thing to keep in mind, though, is you might need to think about your agreement with Microstock. If you've said to Microstock that you are providing that content to them exclusively so that nobody else has rights to license the image or grant permissions, such as yourself, then that could cause a couple of issues. But if you are providing that content to Microstock on a non-exclusive basis, then that will be fine. Are there any other questions at all? I can't see any other questions. I can just see a few comments about audio dropping in and out, so I hope that it corrected itself. Not a problem at all, Apsid. I hope that helped you. If there is anything else that you need clarification on, just let me know. Nicola asked for a copy of the deck. I believe that you can reach out to your local Getty Images office and we can arrange for a copy to be provided to you so that you can reference this in the future. Okay, a question from Alex. There's a few questions coming in now. So if we bought a photo for a website project A, can I use this for another project B? Okay, so this is a great question. And this is one of those examples of why it's so important to know your terms and conditions, because there are many different licensing models. So if you purchased a royalty-free license, for example, sometimes that means that you can use that image worldwide in Project A, in Project B, in Project C. You can use it in as many projects as you like in perpetuity. But if you purchased a rights managed image, for example, or an editorial image, you purchased a license to use that image, then that grant of rights is very specific. It might say use in Project A only. So if you want to use that same image in Project B, you would need to secure another license. So very important to make sure that you understand the licensing model and the terms and conditions that apply to your use. And always ask your representative any questions that you might have about your image or your license. So we have a question from Sherilyn. It says, so if I buy a license for a picture to use on social media, is it usually time-based or medium-based? If it's time-based, can I put it on my social media and do I have to delete it after that time? Once again, a really great question. And that also goes back to that licensing model. If you do have royalty-free rights and you have perpetual use rights, you can use that image again and again. You don't need to remove it off your social media platform. But if you have a specific grant of rights where it says it can only appear for 12 months, you may need to remove it after that 12-month period, or you may need to relicense that image, or you may need to make sure that you have rights that say that you can archive that content in perpetuity. And when I say archive that content in perpetuity, I mean just let that social media feed go on without actually having to remove it, but that you don't make any new uses of that content. Just going up to see a few more questions. A question from Heath. What if I use a photo of a passed over person for further edit, such as Michael Jackson? Is it an infringement? Okay, so there's a few different issues with that one. So if you want to use a image of a past celebrity, so don't forget you need to have permission from the copyright owner of the photograph itself. So that's the copyright side for the photograph. But then there's also the publicity rights of Michael Jackson, which will be now managed by his estate. So even if a celebrity has passed, they still do have rights of publicity, which are often managed by their estates. So if you're going to use it for a commercial purpose, so remember to promote a brand or a company, you would need to think about getting permissions from the estate. If you plan to use the content in an editorial manner, so purely a public interest piece, something that's newsworthy, you might not necessarily need to think about getting those approvals or those permissions. But if it's a commercial use, then most definitely. Another question. I can see that Jessie has made a comment that the seminar will be recorded. Okay, a question from Chloe. In your example, a photo containing a commercial building, so the Taipei 101 Tower, should be concerned. Is it resolvable to purchase a photo online? Okay, so if you're using an image that has a commercial building or any other prominent buildings or landscape or landmarks, such as that Taipei 101 Tower or Singapore Marina Bay Sands, something like that, then if your purpose of your use is commercial, you'd need to think about getting approvals. But once again, if your use is editorial, so purely newsworthy, then you don't need to think about getting approvals from the landmark or from the building owners. You still need permission from the copyright owner of the photograph. Okay, let's have a look. That's a comment from Nicola about the recording. Okay, question from Julia. Google Images has a filter for usage rights where you can search for images that are labelled for reuse with modifications without any restrictions. Another filter limits to non-commercial reuse with modifications. What are your thoughts on this? Really great question. So you need to make sure that you are comfortable to rely on Google. If you're going to use that and you think you're going to use it for a commercial purpose and you think you have those rights, then that's a risk or a risk assumption that you need to make. My personal opinion is that I'd always look to the warranties and indemnities. So when you Google search an image and it says to you that you can use this image in your commercial marketing, for example, do they provide you with any warranties or indemnities? So if a claim comes up, just say somebody contacts you and says, I'm the photographer of that image and I don't actually give you permission. What's going to happen then? Will you be able to rely on Google in that instance? I don't necessarily think so because I don't think that they provide any warranties or indemnities. If you license the content from a photo library, likewise, make sure that you understand the warranties and indemnities that come with your license. So for example, if you're licensing a photograph and we confirm to you that we have all necessary rights to grant you this license, and a photographer was then to come to you and say, I took that photograph, I don't give you rights to use it, you could then come back to that photo library if they gave you these warranties and say, I want to be indemnified for this claim. So it really depends on the terms and conditions and those warranties and indemnities that are offered to you. A question from Alex. If we bought a photo for Client A website project, can Client A get this photo for their usage, for example, PowerPoint, leaflet, etc.? Also really a good question that comes up. So only the rights holder is the only person that has the rights to use the image. So if you have purchased an image or purchased a license to use an image and you're acting as the purchaser purely for that end customer is the rights holder. So they're the ones that can use the image. If they want to use it on other uses such as PowerPoint and leaflet, we need to make sure that they have those rights for future uses, because they may have only had rights for that specific project. But if they do have those very broad grant of rights, then they could use it in future projects. So just remember that the licensee or rights holder is the only one who has the rights to use that content. Next question from Apizit. If I use my picture on my website and then I sell my photo as exclusive, do I need to delete that photo from my website? It's always going to depend on your agreement, your contributor agreement with the relevant picture library. So sometimes those agreements say that your own use of an image is fine and you can use it in your portfolio, but that you can't make any additional licenses of that content, that photo library is the exclusive licensor of that content. So really going to depend on your agreement. But most often, if it's for your own personal uses in your portfolio, it's generally okay. But make sure you refer back to your contributor agreement. I can see another comment that this will be available on YouTube. Okay. Another question from Heath. What happens if I can't find the person for permission in a photo that I use for a commercial? Should I still use that photo? This is going to have to be a risk assessment for you. My personal opinion is that I would not use the photograph if I haven't got the relevant permissions and licenses in place. I would probably opt to use an alternative image where I know I can get the relevant licenses. Comment from Louise. Okay, yep, sending the recording. Okay, a question from Jean. Should the image be an RF image, do we still need to get clearance from the commercial building that is featured? I've always assumed that with royalty-free image, it includes those rights. Once again, great question. So royalty-free content, some content is released and some content is not released. So always make sure that you read that asset detail page, and it will tell you whether that content is released, whether there are model and property releases available. It might also say that no release is required. It might be a picture of a tree, for example, where there's no release from the tree. So don't just assume that because content is RF or royalty-free that it's released. Always important to make sure that you check that asset detail page. Another tip with using content like that is that if it is a cityscape, for example, then you crop that image and you focus on one particular building, you've changed the context of that image. So you might not be indemnified anymore for your use if a claim comes about because of the modification that you've made to that image. So something to keep in mind. Another question, what if I took a photo of something, say a toy, that looks exactly like the same one as I searched on the internet with the same background and color tone? Is it infringement if I further edit the photo? So it can also be a copyright infringement if you copy the idea of another photograph. So if you set something up very similar just to take a photo of it, that can actually also be a copyright infringement because you're copying that creative idea behind that photograph. So it can be an infringement in that case. The other thing to keep in mind as well with those tools such as PicScout is if you do run a reverse image search and you try to find that image, those image search technologies are very clever at identifying very minuscule pixels, so can often pick up if there is a match there. A question from Samantha, are there any underlying risks in using royalty-free images? Once again, really broad question. Depends on your use. Depends if you've used the content in accordance with the terms and conditions of your license. So there's lots of context that needs to be considered there. Royalty-free images, if they are released or don't require releases, are definitely much lower risk than using a rights-managed image, for example, that gives you a specific grant of rights and is not released. The question from Ravenut, if those images, if those images are on social media and the user uses these images for editorial with Getty Images watermark, will these be counted as illegally? So this is going to depend. So if a user is on Facebook, for example, and they see an image that they like and they want to share that post or like that post, for example, then they're using those inherent tools of the social media platform. So that's not actually an infringement. But that person that uploaded the content in the first place, they're the ones that need to make sure that they have a relevant license for their use. And often when I do see content that has a watermark on it, I often actually question if they do have a license. Because if there's a watermark on it, chances are that they haven't received the high-res file without a watermark, so chances are that there's no license in place and will often get picked up. Another question. Hi, what if I need photos of a skyline or building and I went to the ideal location to take the photo? Can I use the image on my commercial project? So if you've taken a skyline shot and there's no particular focus on any one building, no particular focus on any one trademark, for example, a McDonald's trademark that might appear or a Coca-Cola trademark that might appear, then the risk is definitely reduced. But if you take an image and there is a particular focus on one building or one trademark or people, then the risk is actually increased. Are there any more questions at all? I've gone through all those questions that have appeared. I can see also that there are a couple of people that have raised their hand. That's Alex and Jean. Did you need to ask anything? Because I can see that you've raised your hand. Well, if there's no other questions, we might conclude a little earlier then. But feel free, of course. Oh, there's one more question. We'll go through this one quickly. If I use an image with an owner from a different country of usage and the owner happens to see it, would there be any problem in the usage? Yes, there can still be a problem. So wherever the image was taken is where the copyright, of course, is going to exist. And even if you use it in a different country, there's still a copyright infringement that might occur if you don't have the relevant permissions in place. So I've answered all the questions so far in the participant feedback section. So we might conclude a little earlier then, but if you do have any additional questions, feel free to reach out to your local Getty Images office, or alternatively, there will be some collateral that's being sent out after this seminar, and there should be an email address on that collateral. So thank you very much for attending today's seminar.